Good day, Crime Talk aficionados. We have a great show for you today, and you're going to want to stick around for this. First, phone records show that Bryan Kohberger was talking with his mom about the Idaho slayings prior to his arrest. Got a ruling on DNA in the Gilgo Beach murder case. Some legal developments in the Luigi Mangione case. A divine do-over. Chris Watts claims that God has forgiven him for his family wipeout. We have a cautionary tale of a Pueblo man here in Colorado seeks to retract his guilty plea in a murder case, risking much harsher consequences. The feds are eyeing a guy's $95,000 plane over a sneaky six-pack. Guess what? It's headed all the way to the United States Supreme Court. We have this day in legal history. Our quote of the day has to do with mercy, and our dumb criminal of the day tees up a legendary win with pro se panache and a golf deathmatch dare. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can always check us out on any of your favorite podcasting apps. Before we get to the docket, let me remind you, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do a background search on as many people as you desire here in the United States. You plug in a name. The report is literally prepared while you wait. It is emailed to you, and it's going to have all types of information that you want to know about somebody. You're going to get email addresses associated with that person, phone numbers, social media presence. You're going to get a criminal history. You're going to see if they own property. Do they have liens, judgments against them? Are they on one of those sex offender registries? Everything you want to know about somebody that's coming into your life, or maybe whether you're questioning whether they need to leave your life. Is there something they're not telling you? Go with your gut. If you want to check them out, go to crimetalksearch.com. All right, ladies and gentlemen, before we get to today's docket, I want to thank everybody for joining us on our live program last night. I think it was a great show. We talked a lot about the Barry Morphew case. Yes, his bond was not reduced like I predicted, but the judge did modify it, so now it's cash, property, or surety. No need to go into all that again today, but if you want to go check it out, our in-depth discussion about the bond, the process, the judge, check out our live show from last night. All right, let's go ahead and open the record for Wednesday, September 3rd, 2025. And that's right, we have some explosive data from Bryan Kohberger's cell phone indicates that he engaged in discussions about the University of Idaho murders with his mother. That's right, mother, shortly following the incident. So the digital forensic specialist, Heather Barnett, the senior director of forensic research at Celebrite, and Jared Barnhart, head of CX strategy and advocacy at Celebrite, disclosed that Mary Ann Kohberger forwarded her son a news report on the case via text message on November 17th, 2022. The news article described the severe wounds inflicted on the victim, Xana Kernodle, and noting her defensive bruises and resistance, according to Jared Barnett. Now, at the moment of the text transmission, records show the pair were actively on a call, implying the topic may have arisen during their conversation. So, examining the sequence of events, it's evident they were in a phone discussion, leading us to infer they addressed the Idaho killings that evening. That was according to Jared. Now, the experts noted that the unusually extended interactions that day, the hours spent on calls, far exceeding typical patterns. The date also coincided with Kohberger drafting formal complaints to his Washington State University instructors after being mandated to follow a performance-enhancing protocol due to reports of subpar conduct and interactions, particularly with female peers that gave people pause. Now, Kohberger failed to reply to his mother's messaging that evening, and the next morning's exchanges omitted any reference to the crimes, which occurred a mere 10-minute drive from his residence in Pullman, Washington, across the border there from Moscow, Idaho. Now, the forensic team suggested that this gap might indicate deleted texts or that discussions were confirmed in verbal communications, i.e. on a call. Importantly, There is no evidence to suggest that Marianne or other relatives were aware of his involvement before his apprehension or ultimately his admission of guilt. These revelations emerge 4 days post the November 13, 2022 intrusion by the then 30-year-old criminology doctoral candidate there in a Moscow off-campus residence, where he fatally stabbed roommates Kaylee Gonsalves, Madison Mogan, and Zana Kernodle, and her boyfriend, Ethan Chapin. Now, Kohberger was detained approximately 6 weeks later at his family's Pennsylvania residence during the holiday period, and after contesting the accusations for over 2 years, he entered a guilty plea in July of this year, averting the possibility of the death penalty. Now, the prosecutors enlisted Celebrite back in March of 2023 to scrutinize Kohberger's Android device and computer, with the team slated for expert testimony. In prior Daily Mail discussions, they highlighted a profound bond with his parents, Michael and Marianne, marked by frequent lengthy calls to his mother, who he referred to as mother. Often, his mother was the primary point of contact. His phone listed them as mother and father, with minimal outreach to others, such as a dormant group chat with classmates. Now, the communications, like I said, were predominantly with his mom, and it occurred daily and extensively. If unanswered, he would persistently alternate between parents, sometimes appending text post-call. Calls frequently commenced at dawn, like 4 a.m., and extended into the night, resembling a soothing routine. Data further shows a call to his mother merely 2 hours after the attacks. Kohberger deactivated his phone from 2:54 a.m. to 4:48 a.m. on November 13th because he was trying to evade tracking. Executed the murders swiftly and returned home via indirect paths by 5:30 a.m. He initiated contact with mom at 6:13 a.m., redirecting to his father at 6:14 a.m. Upon no response, then reconnecting with her at 6:17 a.m. for 36 minutes. Another 54-minute call followed at 8:03, concluding around 9 a.m., concurrent with his revisit to the crime scene at 9:12 a.m. to 9:21 a.m., the purpose of which, was undisclosed. The bodies were found near about noon later that day. Now, later that day, additional calls totaled over 3 hours. Such frequent early morning interactions aligned with his mom's persistence in custody via video calls, where one episode involved a heated reaction to a perceived slight against him and his mother. Recently disclosed Idaho State Police images depict Kohberger's stark WSU apartment, empty shelves, minimal furnishings, and scant decor. Notable items include birthday cards for his 28th birthday on November 21st, one from his parents evoking sentimental ties to his relocation, and another with humorous annotations referencing egos. His library featured criminology texts such as Unsafe in the Ivory Tower, the sexual victimization of college women, and mass incarceration on trial. Documents included academic work, evaluations, and a remedial plan notice amid grievances from peers labeling him unsettling, misogynistic, prompting warnings of potential risks. Celebrite identified Kohberger's rebuttal drafts to faculty concerns, leading to his dismissal as a teaching assistant and funding loss prior to Christmas of 2022. Police arrested him in December 30th at his parents' home, and then in July of 2025, he pled guilty to the 4 murders, including a 1 count of burglary, getting him 4 multiple life sentences plus 10 years. Now, Marianne, mother, attended key hearings with family members, and he now resides obviously in the Idaho's high security Kuna facility, lodging complaints about other inmates. In a continued push for transparency following Kohberger's sentencing, the District Court of Ada County has issued new orders regarding sealed case documents. So the Judge Hippler in the case, released a second order seeking parties' position regarding sealed documents this week. The order identifies 44 additional sealed filings from April to May of 2025. Ranging from jury instructions and witness lists to discovery responses and motions for alternate perpetrators. Prosecution and defense attorneys must submit positions on unsealing by September 19th of this month as a part of the court's phased review starting from the most recent documents. Now, this follows an August 4th, 2025 order initiating the process. Subsequent rulings have unsealed 15 documents without redactions, citing no valid grounds under Idaho's rules for continued secrecy. Another 13 files were unsealed with targeted redactions, primarily to safeguard personal identifiers like birth dates and name of individuals proposed as alternate suspects, aiming to prevent undue harassment while adhering to the privacy protections under the Idaho Administrative Rule 32. However, 9 documents remain sealed, including those detailing potential alternate perpetrators and materials tied to an ongoing probe into case leaks, deemed exempt from public disclosure. Now, this process pretty much aligns with some post-trial norms, balancing public interest in the high-profile case, marked by obviously intense media scrutiny with the due process safeguards. Now, Kohberger doesn't really have much say in the matter other than his attorneys are, trying to protect whatever privacy they think is necessary, particularly as it relates to the alternate suspect, because some of those alternate suspects information that we've seen was super weak sauce, and for them to actually put that out there, well, it was kind of a Hail Mary attempt. Now, victims' families have expressed mixed views, appreciating clarity but urging caution against sensationalism. Further unsealing could reveal investigation details, and obviously we anticipate delays if appeals were extended as it relates to challenges to what could be released or not. Like I said, my position. My position is release it all. Let the public know. I think we have a right to know. If you don't want to know, don't have to watch, don't have to go look at it. That includes crime scenes and reports, photographs, anything along those lines. Release it all. We're free speech absolutists here, so what can you do? We'll keep you updated as stuff keeps rolling out. It's going to get interesting to see what the defense was really trying to come up with and how thinly veiled it was in the truth. I think one could agree. All right, next on the docket, we had some rulings on some DNA evidence in the Gilgo Beach murder case. So there's been a significant development in the Gilgo Beach murder investigation. Justice Thomas Mazie has ruled that advanced DNA evidence linking suspect Rex Heuermann to the crimes is going to be admissible at trial. This decision, issued during a brief hearing in Riverhead on today, represented a substantial setback for the defense. Now, the evidence stems from nuclear DNA testing conducted by Estrella Forensics, a California-based laboratory specialized in analyzing degraded samples. Using whole genome sequencing, the lab examined rootless hairs found on 6 of the 7 victims. This process involved extracting DNA fragments from the hair and reconstructing them to form a complete profile, which is then compared to the known individual using software called IBD-GEM, G-E-M. The testing identified hairs belonging to Heuermann's former wife, Asa Elsrup, their daughter, Victoria Heuermann, and another associated individual. Prosecutor argues that this connects Heuermann, the 61-year-old architect, to the murders of 7 women who were murdered between 1993 and 2011. Well, it's obviously the real killer is the wife and the daughter. No, ladies and gentlemen. Now, everybody, I'm not saying they are. That was a joke, tongue in cheek, right? Because it's not Heuermann's hair, it's his wife's and daughter's hair. So they must be the real killers. Maybe the defense will argue that. I don't know. But you got to admit, kind of coincidental. Why would Heuermann's wife's and daughter's hair be on the bodies of dead women? That's quite a coincidence to overcome. I mean, literally, the defense could say, because obviously they're guilty, I guess, right? Maybe his wife did it. They could argue that. That could be a real alternate suspect. Kind of a far-fetched. Now, Heuermann obviously is given the presumption of innocence, but today's ruling certainly did not help Mr. Heuermann. So the ruling followed the Fry hearing, during which experts from both sides testified on the reliability of the method of the method, and the judge determined that the whole genome sequencing is generally accepted and reliable within the scientific community, supported by peer-reviewed studies and the application in cases in other states such as Idaho and California. He noted that the defense failed to provide sufficient evidence challenging the technology's validity, despite IBD-GEM being relatively new software grounded in established principles. Now, the Astrea forensic owner, Dr. Richard Green, highlighted during the hearing the lab's expertise in handling ancient or challenging samples, including its contributions to cold cases such as the Zodiac killer investigation. Now, Heuermann's attorneys expressed disagreement with the decision and confirmed plans to appeal, citing concerns over the lab's accreditation and compliance with the New York State standards. And the defense has also moved to divide the case into separate trials, a matter still pending, but my guess is in the name of judicial economy and the fact that it would more than likely be 404B evidence either way, just have a trial with all 6 or 7 of the named victims and try them all as one particular case. The defense really doesn't want to do that, but otherwise you're going to wind up doing the case over and over again 6 or 7 times. Well, the district attorney welcomed the ruling, stating it strengthened the prosecution's position alongside other evidence, including mitochondrial DNA, phone records, witness statements, and other financial data. Now, Heuermann, like I said, has pled not guilty to all charges. He showed no reaction when the judge gave his order. Now, Elrup, the wife, attended the hearing but left promptly afterwards. Victoria Heuermann, the daughter, well, she was not there. So this admissibility determination not only bolsters the case against Mr. Heuermann, initially linked via a vehicle tip and further supported by a planning document found in his home, but also sets a precedent for using the advanced DNA techniques in future New York criminal proceedings. The Gilgo Beach case involved the victims discovered along Ocean Parkway since 2010 had remained unsolved until Heuermann's arrest back in 2023. The next court date, well, it's set for September 23rd. So obviously not a good day for Mr. Heuermann or his wife, who's standing by his side maybe, but at least she's got her documentary gig going for her. Ladies and gentlemen, we've talked about this. Look at the Kohberger case. DNA, you got to be able to explain it. Now, I guess the one good thing is it's not his DNA, but unless you can show that these dead prostitutes were at your house to visit your wife and your daughter, kind of all links back to you now, doesn't it? We'll wait and see, ladies and gentlemen. We'll wait and see. Maybe the appeal will go up now and the courts will reverse it. I think that's highly unlikely. Courts love DNA evidence, even if it is new. I had a case once where they tried to bring in stuff. We had Fry hearings on it as it related. It was a dead baby case, saying that there was starvation, and they were trying to say that they could determine based upon your hair whether you were suffering from starvation. I thought it was complete, total junk science. Judge didn't think so. Neither did the jury. So it's just being a defense attorney, man. You got to challenge it. Right? You become the greatest skeptic, challenge everything, believe nothing unless you can verify it yourself. Next on the docket, let's talk Luigi Mangione. Federal prosecutors have rebutted assertion by defense counsel in the prosecution of Luigi Mangione, who faces charges for the fatal shooting of the United Healthcare CEO, Bryan back in December of 2024. Now, in a recent court filing, the prosecution addressed a defense motion demanding a detailed outline of aggravating factors that the government is going to rely upon to justify the pursuit of the death penalty. The defense had previously argued back in July that the information provided was insufficient and lacked sufficient specificity regarding the evidentiary basis for such a penalty. Well, guess what? The prosecutors maintained that the notice of intent to seek the death penalty, which they had already furnished, satisfies the legal requirements under the statute. Now, the document identifies 2 primary aggravating factors. First, the defendant's actions posed a significant risk of death to others, and the offense involved extensive planning and premeditation. They emphasize that due process mandates no further elaboration beyond what is contained in the notice. The filing highlighted Mangione's alleged preparation as evidence of an ongoing dangerousness, including interstate travel under an assumed identity, obtaining accommodations with falsified documents, conducting surveillance of the victim prior to the incident, consistent use of a disguise to conceal his identity, and possession of an untraceable firearm. These elements, according to the prosecution, demonstrates not only premeditation, but also the defendant's capacity for deception, illegal weapon acquisition, and evasion of authorities, underscoring potential future threats. Prosecutors further noted that procedural rules do not obligate them to disclose a comprehensive evidentiary outline in advance of trial, particularly when no trial date has yet been set. Now, in April, the Attorney General, Pam Bondi, authorized the pursuit of the death penalty, characterizing the killing as an instance of political violence. This marks the first such federal authorization since the resumption of executions under the current administration. So old Luigi Mangione, he's now 27, has garnered significant public attention and financial support, with his defense fund amassing a paltry $1.2 million in contributions. Federally, he's charged with murder involving a firearm, stalking, and related weapon offenses, which could result in capital punishment. Now, in the state charges, state of New York and Pennsylvania as well, include first-degree murder in furtherance of terrorism, second-degree murder, weapons violations, and forgery, carrying a maximum of a life in prison sentence without the possibility of parole. Now, the cases are proceeding concurrently with the state trial anticipated to commence first. Mangione has entered a plea of not guilty to the state charges and awaits arraignment on the federal charges, where he will say not guilty, unless, of course, there's a plea bargain that's been reached. Now, for those who don't recall, police arrested Mangione back on December 9th in 2024 in Pennsylvania, where items recovered included a handgun matching the crime weapon, and a notebook expressing animosity towards the health insurance sector and corporate leaders. Entries reportedly targeted insurance executives specifically, and United Healthcare has confirmed that Mangione was not a policy holder. Interesting. So let's also consider this, because we bring you all the news, ladies and gentlemen. An unauthorized image use in a separate development. That's right. The global fast fashion retailer Shine. The global fast fashion retailer Shine has initiated an internal review following the appearance of an image resembling Luigi Mangione in one of its products. The depiction shows a figure modeling a $10 white shirt with a floral pattern on the company's website, which appears to have been generated via digital editing or artificial intelligence. Shine stated that the image originated from a third-party supplier and was promptly removed upon detection. The company affirmed its commitment to rigorous standards for platform content and announced enhancements to monitoring protocols, along with potential sanctions against the responsible vendor. Now, the duration of the image's presence on the site remains undetermined, as does the identity of the individual or entity that uploaded it. Shine, a leading e-commerce entity focused on affordable, high-volume apparel production, is headquartered in China under the ownership of entrepreneur Chris Yu. Well, ladies and gentlemen, you better get that image down quickly before Luigi Mangione comes for you. Probably going to say you're using his name, image, and likeness, and he wants compensation for that. Next on the docket, a little divine do-over. That's right. Chris Watts claims that God has forgiven him, so, well, why can't we? So in the ultimate little twist of redemption, Colorado's infamous family annihilator, Chris Watts, has announced from his cozy cell that the big man upstairs has given him a holy high five and wiped the slate clean. Because nothing says fresh start like strangling your pregnant wife and suffocating your toddlers. Hey, if God can forgive him, why can't we all just move on? According to prison pen pal revelations unearthed by the Daily Mail, Watts, currently lounging in a life sentence luxury at a Wisconsin's Dodge Correctional Institution, fancies himself a new creature, citing the Corinthians like it's his get out of jail free card. Spoiler alert, It's not. But he says he is a new man, and I am not the person who committed those horrible acts. Yes, the classic "that wasn't me" defense works wonders in therapy, less so much in court. So let's rewind to that fateful August 2018 morning in Frederick, Colorado, just a few miles up the road from the CrimeTalk studios. Watts welcomed home his 15-week pregnant wife, Shanann, from a business trip with a loving chokehold, then chauffeured her body to his oil field workplace for a discreet disposal. Not content with just that, he turned his paternal affections on his daughters, Bella, 4 at the time, and Celeste, 3, smothering them and then stashing their tiny forms in oil drums. Unborn son, collateral damage in the domestic demolition derby. But wait, there's more spiritual sparkle. Watts confesses the real trophy isn't divine judgment. Nope. God's apparently cool with it all, forgiving himself. I know that God does not see me as a sinner who killed his family. He sees me as his child, and I have confessed my sins. I am forgiven, he writes, presumably while pondering life's ironies over prison pudding. The hardest part, extending that grace to numero uno. Oh, and the motive, a steamy side piece named Nicole Kessinger, whom Watts now brands as a Harlow and Jezebel in earlier letters, because nothing screams maturity like biblical slut-shaming for your ex-mistress. She was just everything my wife wasn't like with me. She was just nice and not a control freak. We could make decisions together, he reminisced, apparently forgetting that his ultimate decision involved multiple homicides. In a world where even the government once pondered poisoning cities, shout out to those secret St. Louis Army tests, Watts' tale reminds us forgiveness might be divine, but common sense is evidently optional. Stay tuned. Next up, perhaps a Netflix special on his new creature cooking show from behind bars, perhaps. Ladies and gentlemen, Chris Watts, the story that just keeps giving. That's how we got started talking about the Chris Watts case, and here we are all these years later. Hey, there's been a lot of talk about people withdrawing their guilty pleas, but let's issue a little cautionary tale here of a man just down the road, a couple hours down in Pueblo, Colorado. He seeks to retract his guilty plea in a murder case, risking, a much harsher consequence. So in a development that underscores the perils of second-guessing legal decisions, Gabriel Santiago, a young 20-year-old resident of Pueblo, Colorado, is pursuing the withdrawal of his guilty plea to second-degree murder. Now, court records reveal that Santiago entered his plea back in January of this year as part of a negotiated agreement with the district attorney's office stemming from the fatal shooting of 27-year-old Dominic Adams. Under the terms of the plea deal, prosecutors dismissed the initial first-degree murder charge against Santiago. In return, he admitted guilt to the lesser offense, with the sole sentence stipulation being capping his potential prison term at 20 years, right? So, second-degree murder, 16 to 20-year range, which is pretty good because normally it's 16 to 48. No further agreements on punishment were outlined. But recent filings indicate Santiago's intent to withdraw his plea, and during an off-docket proceeding, his attorney notified the court of the request. Consequently, Judge Tim O'Shea postponed Santiago's sentencing, originally set for August 29th, and set a status conference in October 10th. Kane has until October 8th to submit a formal motion, and as of August 28th, none of that's been filed. So a little background. The charges originated from an event that took place on April 7th of 2025 when the Pueblo police responded to a shot spotter alert at approximately 9:25 p.m. Officers discovered Adams deceased inside a vehicle, exhibiting a gunshot wound to the head with multiple bullet holes visible in the car. Alexandra Santiago, Gabriel's sister, was observed outside the vehicle, positioned near the driver's side, and according to the arrest affidavit, Alexandra Santiago described a tumultuous 3-year relationship with Adams, during which she was pregnant with his child at the time of the incident. She reported prior domestic violence by Adams, leading to his arrest and permanent protection order issued against him back in 2022, naming her as the protected party. Alexandra stated that she had spent the day with her brother, who dropped her off at home using her car. Gabriel remained briefly before departing to take some friends somewhere. Subsequently, Adams arrived at the location, and after repeated questioning, Alexandra admitted witnessing an argument between the two men, despite her efforts to make Adams leave. She closed her eyes during the confrontation and upon reopening them found Adams shot. Gabriel then fled the scene. She further disclosed that Gabriel had previously observed Adams strangling her, harboring strong animosity towards him, and advised her end the relationship. Mutual threats and an alleged prior assault by Adams on Gabriel were also noted. This is where it gets a little cautionary, ladies and gentlemen. Now, Santiago's bid to withdraw his plea serves as a reminder of the risk involved of such maneuvers. Should the court grant this request, the original first-degree murder charge would be reinstated, potentially exposing him to a much more severe penalty, up to life in prison. That's a whole lot more than 20-year cap he secured through that deal. Now, attorneys often advise that one should be careful when they wish for a plea to be withdrawn, as the alternative path may lead to outcomes far graver than anticipated. Santiago is slated to appear in court on October 10th. I guess we'll try to follow his decision. Only time I've ever had an attempt to withdraw a guilty plea work out was a guy went in pro se, spanked his daughter with a belt, kind of out of control teenager type of thing, contacted me, and I said, well, you got a defense of parental discipline. He was allowed to withdraw his guilty plea, proceeded to trial, whereupon a jury promptly found him not guilty. But it usually doesn't work out that way, and it's oftentimes seen as people playing games, and that's why the judges engage in that colloquy with a defendant when they are going to enter a plea of guilty, to make sure they understand what they're pleading guilty to, that they understand the rights they have, the rights they give up, and that their decision is made freely, knowingly, and voluntarily. And on top of that, they know the possible penalties. The judge should, in this particular case, be able to look at the transcript and make sure that the judge checked all those boxes and deny the motion to withdraw his guilty plea, unless he says the attorney threatened him or punished him in some way for that, which I doubt that took place. But there should be nothing there for the judge to act upon, and therefore the motion to withdraw the guilty plea should be withdrawn. Next, a Bush pilot's issue about some beer and his plane is going all the way to the United States Supreme Court. In a tale that's equal parts absurd and infuriating, an 82-year-old Alaskan aviator named Ken Joppy is embroiled in a 13-year legal battle with police over his cherished Cessna, all because a forbidden fizzy beverage in the form of a single six-pack of Budweiser. That's right, you heard that correct. Now, with the help of the Institute for Justice, he's appealing to the United States Supreme Court, arguing that snatching his $95,000 aircraft for such a pint-sized offense smacks of Eighth Amendment overkill. So here's what went down. Back in 2012, state troopers in Alaska rummaged through Joppy's plane before it could taxi off into the wild blue yonder. They uncovered a passenger's stash of beer bound for a dry village where booze is banned faster than you can say last call. Joppy, his only sin was that the lone six-pack sitting in plain view, earning him a misdemeanor slap on the wrist. But the government wasn't content with a mere ticket. They've been circling like vultures ever since, invoking asset forfeiture to claim his plane as spoils of the sudsy skirmish. Now, the Institute for Justice, those plucky defenders of the little guy, fired off a petition to the Supreme Court urging them to clarify if fines should weigh the actual misdeed or just wax poetic about society's broader boozy woes. This is the excessive fines clause and doing what it was born to do, curbing bureaucrats' beer grabs, quipped Sam Gage, a top attorney at the firm, in a statement that drips with irony about agencies treating forfeitures like their personal ATM machine. This isn't the Institute's first rodeo at this high court. 6 years ago, they scored a win when the justices decreed that states can't ignore the Eighth Amendment's ban on outrageous penalties, spotlighting a case where Indiana cops nabbed a fancy Land Rover over a small-time drug bust. That ruling placed the onus on states to define excessive leading some, like Indiana's own court, to adopt proportionality, eventually returning the vehicle after years of legal battles. But not everyone got the memo. Courts in places like Alaska and the federal 11th Circuit prefer a loftier lens, examining maximum penalties for hypothetical horror stories and the grander societal scourge the laws aim to eradicate. So in April, Alaska's top bench gave the green light to yoinking Jop's Cessna, solemnly intoning that even a humble half-dozen brews fuels rural rampage, health havocs, and a tab on taxpayers. Grave social harm, they declared, as if the six-pack were a Trojan horse for Armageddon. The Institute counters that this approach mocks the Constitution's plain-spoken shield against wallet-whacking punishments, whether civil or criminal. For Joppy, it transcends personal plight. At his age, after battling this beast for over a decade, it's about making sure the Bill of Rights isn't just fancy paper. It's a real bulwark against Big Brother's over-eager hands. If the Supremes bite, it could pour cooled water on forfeiture frenzies nationwide, proving that sometimes justice is best served chilled, but not confiscated. Next on the docket, this day in legal history. September 3rd, 1758, the New Jersey legislature establishes the first Indian reservation in America. I guess I could say that started the legal framework for Native American land rights. On September 3rd, 1838, abolitionist and human rights advocate Frederick Douglass escaped from slavery in Baltimore by posing as a free sailor and boarding a train bound for Philadelphia. On September 3rd, 1862, the U.S. Department of Treasury establishes the Bureau of Engraving and Printing to produce paper currency, kind of a big development in federal financial regulations and anti-counterfeiting laws. On this date in 1787, during the Constitutional Convention in Philadelphia, delegates debated and commit proposals to uniform bankruptcy laws, the full faith and credit clause, a fugitive slave provision, and rules for admitting new states into the Union. And let's roll in then to our quote of the day. Today it's regarding mercy. Let this one sink in. Every dog is allowed one bite. That's deep, isn't it? Yeah. Sometimes you got to keep it simple, ladies and gentlemen. And then finally, our dumb criminal of the day. All right, Ryan Wesley Ruth tees up a legendary win with pro se panache. That's right. In a stroke of genius that elevates courtroom drama to the level of a satirical sitcom, Ryan Wesley Ruth, our undisputed dumb criminal of the day, has boldly opted to represent himself in the upcoming trial, turning what could have been a somber affair into a masterclass in audacious absurdity. Facing charges that could land him in prison for life, including attempted assassination of a major presidential candidate and assaulting a federal officer, Ruth has instead proposed settling the score on the fairway, a high-stakes 18-hole golf match against Donald Trump himself. And in this reimagined narrative, our hero emerges victorious, not with a bullet, but with a putter and a panache for procedural pandemonium. Here we go. Now, Ruth, the 59-year-old would-be marksman caught lurking in the bushes at Trump International Golf Course in Palm Beach back on September 15th of last year, rifle in hand, allegedly plotting to disrupt Trump's campaign trail swing, and prosecutors paint a picture of a week-long scheming thwarted only by a vigilant Secret Service agent who fired first, sending Ruth scampering after the shots. This came hot on the heels of Trump's narrow escape in Butler, Pennsylvania, just 8 weeks prior. But why dwell on the drama when Ruth has ingeniously flipped the script? In his self-filed motion, a deranged delight submitted just days before jury selection kicks off on September 8th, he challenges the former president to a duel of dimples and divots. A round of golf with that racist pig, he quips in the document. He wins, he can execute me. I win, I get his job. Oh, the irony. By daring Trump to this golf death match, Ruth not only sidesteps the tedium of traditional testimony, but positions himself as the plucky underdog, ready to out-putt the baboon, as he described him, on his own turf. Well, the judge has tentatively greenlit his pro se pursuit with standby counsel on hand should things get veered off course just a little bit, though she has promised to keep him on a tight leash, lest any sudden swings invite martial intervention. But Ruth's filing isn't just a challenge, it's a wish list wrapped in whimsy. Slamming prosecutors for last-minute evidence introductions, he barters boldly. If you would like to trade admitting the evidence for my subpoenaing the baboon, Donald J. Trump, bring that idiot on. It's a deal. He envisions the showdown in shackles and cuffs, taunting. Give me shackles and cuffs and let the old fat man give it his worst. We must beat down crime in America. Carpet is red, isn't it? No harm in blood. For trial prep, he demands a serene suit with case documents, a phone visitation, email, a typewriter, and a flourish of flair, female strippers, plus a putting green to hone his short game. A golf joke, he deadpans, ensuring we all get the punchline. In the crowning Ruth, our dumb criminal of the day, we celebrate not folly, but flair. By going pro se and lobbing this golf grenade, he's transformed a potential tragedy into a tea-time triumph, outwitting expectations and leaving us wondering, who needs lawyers when you've got irons and irreverence? As the trial tees off, one thing's clear, Ruth has already sunk a hole-in-one in the annals of legal lunacy. Ladies and gentlemen, can't make this stuff up. That's all we have for today. Thanks for watching. Go check out our live program last night regarding a discussion of the Barry Morphew case and his bond reduction and kind of the procedures going on. And we'll see you tomorrow. And remember, the Constitution matters.